is Michael Popok, Legal AF After Dark. Immunity, immunity, immunity. No, it's not Beetlejuice. It's Donald Trump's allergy to winning on the issue of immunity. He lost in the civil case at the D.C. Court of Appeals to try to stop lawsuits against him for Jan 6. He lost in the criminal case with Judge Chutkan to use immunity to stop the criminal trial against him. That's going to trial in March. And he's lost now, all within 20 days. Immunity defense for the Jean Caroll second defamation case going to trial in just a month. We talk about it. We analyze it. We debate it. One place and one place only on the MeidasTouch Network. Legal AF. Take a listen.
Below, we talked a lot about the repercussions of the reverberations, if you will, of the Giuliani verdict on the Trump defamation case. But one of the things that's paving the way for this Trump defamation case, Michael Popok, are some serious errors that were made by Donald Trump's legal team. Surprise, surprise. And failing to assert absolute presidential immunity in a case involving defamation while Donald Trump was in office by Trump's legal team is kind of a check the box, wink, wink error, if you will. To be clear, if you want to cite something or you want to assert an affirmative defense, it's literally a sentence in your answer. You just put, as for the third affirmative defense, Donald Trump hereby asserts absolute presidential immunity. And then you could assert it. You don't waive it until the time of trial. You could bring it up on summary judgment. You could potentially even bring it up on the eve of trial if you've asserted it as an affirmative defense. But you see, Donald Trump's legal team, and again, in this Jean Caroll case, just a reminder, involves Donald Trump's statements while he was in office during press conferences where he defamed Jean Caroll. You'll remember, well, what were all these appeals about? The appeals were really jurisdictional. That was when Bill Barr tried to assist Donald Trump and substitute in the United States government in place of Donald Trump. And that's what went up on appeal, whether or not the government should be substituted. So all of these appeals, Michael Popok, were over kind of the course and scope employment analysis about whether the government should be substituted in. But these appeals did not involve the other question, because Donald Trump's lawyers didn't assert absolute presidential immunity until like months ago, like not too far long ago, where they tried to bring it up for the first time when Jean Caroll amended the complaint just slightly based on the new statements that Donald Trump had made after the defamation case back in May when Donald Trump went on that so-called CNN town hall. And then the judge said, no, you can't bring up absolute presidential immunity on the eve of the next defamation case. You had 3 years to assert this as an affirmative defense. And your lawyers, when you were sued for years, year 1, year 2, year 3, never raised this issue of absolute presidential immunity. You've waived it. We're not letting you even bring this up at the trial. So Donald Trump appealed that to the Second Circuit. And in a scathing order, the Second Circuit Court of Appeals said, waiver, you waived it. You can't assert absolute presidential immunity here. And here's the thing, Popok, I want to get your take too. As abhorrent, as despicable as Donald Trump's conduct was, this is an objective show here on Legal AF. He had a decent shot, not before Judge Kaplan, the federal judge, but I think before the Second Circuit Court of Appeals, or at least the United States Supreme Court, to actually make an absolute presidential immunity argument as it relates to the defamation case brought against him, because it is not a course and scope of employment argument. It is an issue of absolute presidential immunity. And if you go back to the Nixon v. Fitzgerald case, which is one of the preeminent cases on absolute presidential immunity, that case involved an unlawful act, an unlawful retaliatory termination. But the Supreme Court said if it falls in the outer perimeter of presidential authority, hiring and firing, even if the president engaged in something unlawful, or a former president while they were in office engaged in something unlawful, if it's within the type of things they do as Article 2 and it's not criminal and it's civil in nature, you are immune from civil damages. The difference in the Blasingame case involving the January 6th insurrection, why that's distinguishable, is that the conduct falls outside the outer perimeter, right? Because it involves election and campaigning. Nothing to do with Article 2 executive authority there. But the Jean Caroll, Trump could have made an argument and said, it was a press conference while I was in office. It could be despicable conduct, but it happened while I was in office. Former presidents, when they were in office, they engage in press conferences, they engage in interviews with the media, and I was asked these questions, and I could have seen the Supreme Court actually biting on that one. Thankfully, he waived the issue, and now he's going to get hit with a massive verdict. And by the way, I want to be clear. I don't think he should have immunity for that. I think Judge Kaplan would have found that Trump does not have immunity for it under absolute presidential immunity. I think ultimately, though, a court of appeals or the Supreme Court may have disagreed, and he had a shot of getting the case dismissed on that ground. What do you think, Popok?
About the only good thing that's come out of Trump, Giuliani, Meadows, the criminal prosecutions and the civil lawsuits is that it's developing a new body of law that will now be used against them in the future or others worse than them or like them in the future. We have now a well-developed body of law about immunity, civil application, criminal application, and that concept that you just talked about, the outer perimeter, outer boundaries. Sounds like an old 1960s sci-fi TV show. I used to watch a show called The Outer Limits. That is now in the vernacular for a good reason, because we've had a series of cases that have been now decided by at least the D.C. Court of Appeals, which is the highest court in the land other than the United States Supreme Court when it comes to constitutional things like this, having already made decisions, as you said earlier, the Blassingham decision, setting the outer boundaries of misconduct that can, if it falls outside those outer boundaries, be a subject of a civil lawsuit for torts and damage recovery. We have the criminal side of outer boundary analysis when it comes to immunity that we're seeing now being developed through Judge Chutkan's original decision, citing back to Blassingham that there is no presidential immunity for criminal conduct automatic. You have to go look at if he was inside or outside the course and scope or the his Article 2 powers. And then we're not going to touch on it much today, but similarly in the same breath this week, we've got another appellate court, the 11th Circuit, I would say struggling, but I don't think they're struggling based on the oral argument as to whether Mark Meadows was inside or at the outer perimeters outside of his federal officer duties in order to enjoy the ability to trigger federal officer removal to take his Georgia prosecution from state to federal court. And if the oral argument is any indication, and I did a hot take on this one, he is staying firmly in the Georgia state prosecution. That is the only great thing that comes out of the wheels of justice about, I'd rather not have had the conduct to have had now developed all of this new line of immunity cases. But as you said, what we've now learned is that presidential immunity is something you have to use or waive. You have to assert or you've lost it. And we weren't sure about that before, because some people might be scratching their head even on this show and saying, well, wait a minute, what's going on with the criminal case and Judge Chutkan? Why is that case stayed awaiting an expedited resolution of immunity either by the D.C. Court of Appeals or the U.S. Supreme Court on a direct appeal? We'll talk about that in the next segment. Why is that different? Well, it's different because you're talking about criminal rights. And if it's a criminal case with the liberty of somebody, in this case a former president, at risk, you don't want to put him through the trial and then find out that he had immunity. You want to, because that's a pretty serious set of consequences if he had immunity all along. You want to get that thing decided early as to whether, based on the record that's been developed, he is either inside or outside the outer boundaries or perimeter of his presidential authority or powers before you go off and just pull a jury and start.
Popok, can I say something? Just one thing, right?
Of course.
Just the one thing right there, though, and I apologize for interrupting, is, but still Donald Trump at least asserted it on time later than people would like. He at least asserted it on time. In Blasingham, he asserted it on time. In Jean Caroll, he never asserted it.
Agreed. But I was making a slightly different point, but I agree with you on that. This is the point I was trying to make. In the criminal setting, I don't think it mattered when he asserted it. I think it divests jurisdiction, and the court has to decide at that moment immunity. We don't have to get to that because it's not really he asserted it.
But can I ask you a question on
sure.
that? Say I disagree because,
Okay,
so you're telling me then you go through all of the criminal trial. On the eve of a verdict, the jury's out. Can Trump then go, you see what I mean? Can he go on the eve of, at any point in time, on the eve of a verdict, you go through 3 months of a criminal trial, then could Donald Trump say absolute presidential immunity? I still think there has to be a moment where you have to declare it.
Yeah, the good news, you're right. I agree with you. I think waiting till while the jury's still out, wait a minute, I was the president. Why am I here? I think you're right about that. It's not an issue that was that will be in the cases that we'll talk about next involving Donald Trump. But as you back to the difference between, I was really making the point of, does it divest the court of jurisdiction or not? Because if it's something that can't be waived, then it doesn't. The waivability of the issue is at stake in the Second Circuit decision about Jean Caroll. I just don't think that's the issue. And yes, he raised it a little bit late for my liking, but he raised the right immunity issue on the criminal side. On the Jean Caroll thing, that was a complete screw up by Alina Habba. She got obviously confused. She was handling the case for most of this. Joe Tacopina came in 3 months before the trial and took over, but she was running the day-to-day show. She made a number of errors. The reason that the blue dress coat wasn't used in the trial is because of Alina Habba screwing up in the timing of when she asked for certain things. And I think she got confused when the two trials got separated and one got stayed and one moved forward. She had never raised in 2.5 years, never in her answer, that there was presidential immunity in play. And as you said, unlike in a state court proceeding where you often have to put a lot of facts behind your defenses, all you have to do in federal court, it's a notice pleading concept. All you got to do is one line: unclean hands, presidential immunity, statute of limitations, latches, one line. That's all she had to do. And it was a mistake, because she should have at least raised it so that the issue got resolved on the merits on the appeal. I think she was surprised. You and I did hot takes on this. We played the audio of the oral argument that she got caught so flat-footed. Her only argument then became, this could never be waived. It can't be waived. It doesn't matter whether we're late. It's unwaivable. And the judges were like, I mean, it was written by Judge Jose Cabranes, but the judges at the time were like, I don't understand that. I could envision, can't you ever envision a time where a president, maybe not named Donald Trump, would be willing to waive presidential immunity in order to clear his name and try the case on the merits? And she said, no. Like, he's been accused of being a rapist. Don't you think he doesn't want to get out on an immunity technicality? He may want to, put on the evidence that it didn't happen. And she was like, nope, can't ever waive it. And so that was already a loser argument. When they finally got around to ruling, we now have precedent, because there's no conflict among the circuits. We have the only federal appellate court decision on the issue, which is you can waive presidential immunity if you don't raise it early enough. And it's exactly the way you said it. How late can you let him raise it? You can raise it while the jury's still deliberating and go through that process and 2 bites at the apple. So no, he'll try to take that appeal, but he'll have to go through Judge Sotomayor, who's the associate judge in New York who sits over the Second Circuit. And she'll either reject it on her own, like, no, or, which has been their habit lately because of all the flack they've gotten, understandably, because of their ethics, is that she'll refer it over to the full appellate panel, the full Supreme Court, and see if any of the 9 want to take on that appeal or not at this moment. But we are watching, and we'll talk about it in the next couple of segments, we are watching that the Supreme Court we're getting to the point where they're waking up and getting involved now with things related to Donald Trump that matter. But these are the stepping stones and are now the precedent that other courts need to apply, unless they're going to do something different, set up a conflict in the circuits, and then the Supremes at some point have to decide it. We're running out of time. I mean, I'm not talking to you, Ben. I'm talking just out loud. We're running out of time. This is January already, effectively. A trial in March, an election in November. Things have got to move at a high velocity. Appeal, trial, decision making, and the rest. And I think we're starting to see it with how the DC Court of Appeals, which is usually the first stop on this constitutional immunity presidential train, and then even the U.S. Supreme Court are saying, whatever we're going to do, almost like Bush versus Gore when in 2000, we got to do this quickly.
You know, there was another oral argument before the Second Circuit Court of Appeals in a case involving Michael Cohen, where Cohen was challenging the unconstitutional remand for purposes of Michael Cohen's lawsuit that he filed when he was remanded into custody and put in solitary confinement because he wouldn't waive away his rights to put out a book in 2020. For purposes of that, basically everyone stipulated, okay, assume it is a constitutional violation. Is there a remedy? Because the right-wing Supreme Court over the past 3 decades has gutted a doctrine called Bivens, which used to find implied causes of action in the Constitution for kind of basic constitutional wrongs. The right-wing Supreme Court's been saying, well, Congress needs to pass a specific remedy on a specific point, or else we can't acknowledge implied causes of right. So one of the issues on appeal is, does Cohen have a remedy for the constitutional wrong that was committed? The only reason I'm bringing it up is that Alina Habba was arguing for Donald Trump and tried to assert not official acts immunity, but absolute presidential immunity. So the Second Circuit panel had questions for her about the Blassingame case, right? The key case. And she goes, I have to check my notes. I don't know what the Blassingame case stands for. And then the Second Circuit panel goes, you don't know Blassingame? And she goes, no, I'm sorry, but I can talk about the Nixon v. Fitzgerald case. And it's like everybody who listens and watches Legal AF, you all know the Blassingame case. And it wasn't like it was decided decades ago. It was decided 2 weeks ago. And it's the case involving absolute presidential immunity involving her client. It's basically her case. And she doesn't know what Blassingame stands for, that Donald Trump does not have absolute presidential immunity in civil lawsuits relating to the conduct involving the insurrection, because it's campaign activity or election activity. So she couldn't answer. And then the panel was basically like, sit down, Alina Habba. I think that's a good segue into now what the DC Circuit Court of Appeals is doing, because the DC Circuit Court of Appeals is the court that made the finding in Blassingame, finding that Donald Trump does not have absolute presidential immunity in civil cases. Now, the DC Circuit Court of Appeals, they're the bosses for federal judge Tanya Chutkan, the district court judge overseeing the trial that special counsel Jack Smith's prosecuting Donald Trump for attempting to overthrow the results of the 2020 election that's scheduled for March 4th of 2024. And Judge Chutkan says in a criminal case, unlike a civil case, in civil cases, the doctrine of absolute presidential immunity exists. It is established. Donald Trump doesn't have it in January 6 cases, as the DC Circuit Court of Appeals said. But Judge Chutkan found for an independent reason that Donald Trump doesn't have absolute presidential immunity. She found there is no such thing as absolute presidential immunity in criminal cases. So Donald Trump, for former presidents, Donald Trump is appealing that to the DC Circuit Court of Appeals. And as I've said before, there's now 2 independent reasons why this should be a no-brainer for the DC Circuit Court of Appeals. The logic by Judge Tanya Chutkan that how could you have absolute presidential immunity in criminal cases? That means that former presidents during the time they were in office could act as kings. They can do whatever they want. They could summon the military and have a coup. They could do anything and say, ha ha, we're not responsible. That clearly can't be what the text, the structure, or the history of our Constitution is all about. But then the second reason is Blassingame. Donald Trump's conduct, while criminal, also relates to the January 6th insurrection, because the DC Circuit Court of Appeals found that the insurrection conduct relating to Donald Trump, as alleged in the Blassingame case, is outside the outer perimeter of absolute presidential immunity. He doesn't have it for that reason. So there's 2 powerful reasons right here that both go hand in glove. The one thing that I'm surprised special counsel Jack Smith didn't do, because Jack Smith's been super aggressive and did a few really powerful moves, I'm just surprised he didn't, and this could just be because he thought this could cause more delay, but tell Judge Tanya Chutkan that Donald Trump's appeal because of Blassingame is frivolous. to try to certify the appeal as a frivolous appeal from the outset. But I think special counsel Jack Smith knew that the DC Circuit Court of Appeals kind of knew that and would expedite it. So, right, Jack Smith did two things. One, filed a direct petition to the United States Supreme Court for certiorari, saying this is an extraordinary case. Certiorari, or oral argument, should happen in this term immediately before going through the normal years and years and years it takes cases to go to the Supreme Court, because this is so fundamental, so foundational to our democracy. Supreme Court responds right away, says, Donald Trump, you have until December 20th to respond to the issue of whether or not certiorari should be granted. So the Supreme Court not granting certiorari yet. They haven't decided that. That's the oral argument before them on the issue of absolute presidential immunity, but granting special counsel Jack Smith's request to expedite the briefing. That's in front of the Supreme Court. Meanwhile, special counsel Jack Smith filed a motion to expedite the briefing on the issue of absolute presidential immunity before the DC Circuit Court of Appeals. Jack Smith needed to do that, especially because federal judge Tanya Chutkan, the judge who I just mentioned who's overseeing the trial, who's a great law and order, no nonsense judge, she looked at the law and said, my hands are kind of tied here. Absolute presidential immunity seems to encompass the entire case. And there is a doctrine called Griggs, which says on an appeal to the DC Circuit or to whatever the appellate circuit court is, it stays the district court proceedings. There's a recent case that came out called Coinbase versus Bielski, and applying the Griggs doctrine, applying Coinbase, and applying the logic, at least, of the Blassingame case that talks about if absolute presidential immunity exists, it means that no proceedings can take place, even though Blassingame ruled against Trump. She basically said, Judge Tanya Chutkan said, look, my hands are tied. I have to stay the proceedings here. I'm not going to vacate my trial dates. I'm going to keep the trial dates on, but I can't have any more proceedings here. So special counsel Jack Smith has to run to the DC Circuit Court of Appeals to expedite this briefing. Donald Trump thinks he gets a big win by having the case delayed and stayed by Judge Tanya Chutkan. So Donald Trump feels he got great news in the morning for his delay strategy. But then the DC Circuit Court of Appeals says, not so fast, not so fast. And boom, they hit him with this briefing schedule that is as expedited as you can be before the DC Circuit Court of Appeals. Trump's brief is due December 20th on the issue of absolute presidential immunity, which was denied by Judge Tanya Chutkan. Jack Smith's is due December 30th, and then Trump's reply brief is due January 2nd, 2024. So all of the briefing now will be due, we're talking about, in the next 20 days. So in terms of a delay, we're looking at more like a 45 to 60 day delay of Judge Tanya Chutkan's proceedings by the time oral argument is scheduled, which I think will be sometime around January 10th to 15th. So Trump is getting, I think, a delay, not the delay he wanted. And I think this can still be kept on track. A lot of concepts there that I wanted to throw out to kind of, before I hit you with the analysis, Popok, that you can give our legal AFers out there on all of that. But that's a lot of moving parts.
Yeah, so there's two things that happened back to back at the U.S. Supreme Court. One, they thought it was interesting as to whether the appeal of the immunity issue should be decided by them directly rather than have the record more fully completed below and let the D.C. Intermediary Court decide it first. Jack Smith did the right thing. You and I said a couple of weeks ago that when there was some misreporting about, oh no, the appeal at the DC Court of Appeals based on an order spit out by an automated service system says that his next big piece of paper he has to file in the appeal is late December. Oh no. And we said, relax. First of all, either the panel is going to get in place and make a decision that goes faster than that, or Jack Smith's going to do something to force their hand. And right on cue, Jack Smith did two things to show how serious this is. And he'll take either one. One is to get the Supreme Court interested on the issue of this is such an important issue that we don't even have to go to the lower level intermediary court, even though you're a court of limited jurisdiction, Supreme Court. You can do this and should do this directly. And that, of course, was a wake-up call because that got decided first by the Supreme Court. And then hours later, the D.C. Court of Appeals said, no, we're going to do this expedited too on the actual issue we have jurisdiction over the appeal. Let's do this on an expedited issue. First, they said, let's have expedited briefing on whether we should have an expedited appeal. Donald Trump cited The Grinch That Stole Christmas. I'm not making this up. HarperCollins, 1957, for those that are following the copyright, and Wasted Ink telling the panel, oh my God, we have to work over Christmas? That sounds terrible. And like an hour later, the panel said, okay, so we're having an expedited appeal. And here's the briefing schedule that, Ben, you just read out there. At the same time, the Supreme Court said, oh, hold on, we're going to figure out whether at the same time, don't stop anything. We'll do this all parallel, all out in the open. We'll figure out whether we want to take the appeal directly or have them say, after seeing the briefing there, you guys look like you're in good hands with the DC Court of Appeals. Finish up there. If there's an issue, come back and see us. That's where it's going to go. I'm not sure yet, except we have to read something into the fact that within 2 days after they decided, the Supreme Court, to take the issue up to them, whether they have or want jurisdiction to be asserted by the Supreme Court on the immunity issue now or wait. It's a timing issue. It's not well, we're going to stay out of it forevermore. It's, do we want to do it right now, or do we want to do it after our lower level appellate court goes first? That's the only issue that's really up there, but it's important. As I said, the velocity of this is important. If we're going to hit a March, April-ish trial date for Donald Trump, it's got to happen then. And then if she'll just start her trial, just to answer the question on some people's minds, Judge Chuck is not going to care if Aileen Cannon has double booked restaurants, like she's on some sort of judicial open table, and she's not sure she's really going to use that appointment or not. Chuck is just going to start a trial. And if the other one happens or doesn't happen, she's going to let the lawyers run around and argue, oh my God, we have 2 trials back to back or whatever it is. But she's just going to go forward. If she loses a month or a week or 2 weeks or whatever it ends up being on this fast track, then so be it. So you got that going on. But at the same time and in the same breath, you've got the Supreme Court sending another message, which is, we're going to have our first opportunity to tell the Department of Justice, and therefore the world, whether the obstruction of an official proceeding, whether these Jan 6 insurrectionists, these Jan 6 defendants, were properly charged, or were they overcharged, as that concept is used in prosecutor world? Were they overcharged with crimes that don't fit the facts? These are very novel facts. We've never, other than in the 1800s, had an attack on our capital by domestic terrorists, defendants. So, prosecutors have to take existing law. They can't make up crime on the spot. Criminal statutes on the spot, take existing law and map it onto novel facts. And if they get it right, they're great. If they get it a little wrong, that's called overcharging. And so the question is, have they overcharged in using the 20-year sentence, which is the highest level other than seditious conspiracy, which they've used to obtain hundreds of convictions, either by plea, by bench trial, or by jury verdict already. And then Donald Trump has 2 of his 4 counts in the DC case are whether he corruptly attempted to interfere with an official proceeding, congressional proceeding, which is the certificate count, the certification of the electoral votes. How did we get here? We got here because Judge Nichols at the DC judge said, I thought it was a bridge too far. He said that particular statute, which came out of the 2002 Enron financial debacle, deals with sort of white-collar crime and somebody really ripping up the ballots, destroying evidence and that type of thing, not, attacking the Capitol at the right moment to stop the certification. God, that sounds like corruptly trying to stop a official congressional proceeding to me. But to Judge Nichols, if you didn't physically get your hands on the certificates, go up to Mike Pence at the podium and rip them out of your hands, then that statute didn't apply. Although that's nowhere in the language of the statute. So that's the appeal. What do you have to do to constitute corruptly, willfully interfering with a congressional proceeding, and has it been properly applied? If the Supremes were to rule, for instance, that it was not properly, it's not properly a count that should be used against these people on these facts, then that's going to send people out of the jails, because there's lots of people serving time right now because they got convicted on that count. And it will vacate sentences unless they were convicted of something else, which a lot of them were, and everything else. And for Donald Trump, it means, if depending upon when the ruling comes out, they either have to drop 2 of the 4 counts against him. They've got 2 other. having to do with defrauding the U.S. government and suppressing the vote, but they'd lose the two highest value crimes on the indictment, Jack Smith would, if this Supreme Court case comes out. Now, normally, when you're doing, when they decide to take up a case in January, which is effectively now, you don't get a ruling after briefing and oral argument until like June. If this trial happens in March or April, that's not going to help Donald Trump. If he got convicted, they later ruled that he shouldn't have been, then on appeal, he'd be able to have that portion of his conviction vacated, although that's not the perfect world for Jack Smith to be in. But there's a message being sent, and I want to hear your view on it, by the Supreme Court in saying, yes, we're going to figure out whether we should be dealing with immunity right now in Donald Trump. And by the way, half of your indictment, we're going to decide whether that was properly charged or not. Get that out of the way right now. I have a theory. I did it on my hot take. I want to hear what your theory is about the messaging and what do you think they do? I want to hear your prediction on, do they take the direct appeal or make it go back through the D.C. Court of Appeals, giving the timing here? And secondly, what do you think they ultimately do with the charge of that charge being applied and mapped on to Donald Trump and the other insurrectionist conduct?
I'll tell you what I think after our last quick break of the day.
Well, if you like that, lawyers who think they know what they're talking about when it comes to politics, law, and justice, and they do it twice a week, every week on the MeidasTouch Network and on hot takes just like this one, then you'll love Legal AF. If you already know about Legal AF and you already like us, great. Welcome back. We appreciate you. Take that clip, send it to others around your life and that you like to have them join us and say, here's a clip, take a look. If you don't know what I'm talking about, I'm Michael Popok. That was a clip from Legal AF, and you can join us every Wednesday and Saturday at 8 p.m. Eastern Time on the MeidasTouch Network. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.